Hello guys, and welcome back to my YouTube channel. My name is Ahmed and this is Law Talks with Ummaty. Today we're diving into a topic that concerns every creator and artist out there: copyright law in Nigeria and how to protect your creative work. Whether you're a musician, a writer, a YouTuber, or any kind of content creator, this video is a must watch. So let's get started. Let us first start by understanding copyright. Copyright is a legal term used to describe the rights that creators have over their literary and artistic works. Copyright grants creators exclusive rights to their original works, and these works are literary works such as books, poems, plays, textbooks, law reports, anthologies, anything written, musical work, and this is any musical composition or melody. Artistic works, this includes paintings, drawings, etchings, engravings, and prints, such as photographs, works of architecture in the form of building models. And then there is audiovisual works. There is sound recordings, such as podcasts or radio play, and lastly, broadcasts. So there are 6 kinds of creative works that copyright protects. Basically, if you create it, you own it. For instance, think of a hit song by your favorite Nigerian artist. The lyrics falls under literary works, melody falls under sound recording, and the music video falls under audiovisual works. All of these are protected by copyright. The same goes for books, paintings, and broadcasts. However, for you to have a valid claim of copyright, your work must be fixed in a definite medium of expression. That means it must be put in a permanent form so it can be perceived. You can't have copyright over ideas which have not been put in a permanent form. For example, you can't say that you had an idea to make a flying car, and because someone made it before you, you sue them for copyright infringement. It doesn't work that way. You must have gone out and made that car before you can claim any kind of copyright with regards to it. Also, copyright protects original forms of expression and not ideas or facts. So therefore, your work must be original, and this means that the work must come from you. You made it. It must not be copied from another work, but it should originate from you. So if you create something and have copyright in it, you have the right to do the following things with it. You can reproduce it, you can publish it, you can communicate it to the public or sell it, you can perform, you can translate, and a number of other things with your work because it belongs to you and you made it. You can be the author of a work and the owner. That means you made it and you own it. But sometimes you can be the author of a work but not the owner. You made it but it doesn't belong to you. So if you produce a piece of work under a contract of employment, copyright belongs to your employer unless there is a contract that says otherwise. So I'm a freelance writer and I write for a blog. When I started working for them, I signed a contract. Now, every article I write for them means they have copyright. I am the author of the article, but they are the owners of the copyright. However, you can work for someone and they could not have the copyright to your work. And this can occur when the work you created was not done during the course of employment or on the premises of the employer using their facilities or materials. Now, let's tackle the serious stuff. Copyright infringement. This is when someone uses your copyrighted work without permission. Remember that song example of your favorite artist. Imagine someone using it in their own video without proper authorization. The acts which constitute infringement under copyright law are those acts which are exclusive to the owner of the rights. Those things only the owner of the copyrighted work can do. We'll begin with reproduction. For example, an owner has an exclusive right to reproduce his work. When another person reproduces your work without your consent, they are violating your right. And reproduction doesn't only mean making copies of the work in the same format, such as when people make copies of shows that are meant to be streamed in the form of CDs for sale. You see them in the markets. It also means reproduction of the work in other material forms. In the case of King's Features Syndicate versus O&M Kleeman Limited, the plaintiff made artwork consisting of sketches and cartoons, and the defendants, without his permission, took those paintings and modeled their toys after his drawings. So basically took his drawings and made them in material form. It was held to be copyright infringement. In Nigeria, cases of copyright infringement most of the time involve unauthorized copying of the entire work of another person. For example, in the case of Peter Obe versus Grapevines Communications, a professional photographer sued a company for taking his pictures that he snapped during the Civil War and reproducing them as well as publishing them in their magazine without his consent and without, giving him credit. Publication of a copyrighted work without consent also amounts to copyright infringement. In the case of Adenuga versus Ilesami Press and Sons, the appellant sued the company for publishing his book without his consent and selling copies of it. It was held that the press had committed copyright infringement. Distributing someone's work through selling, hiring it out, or otherwise without the owner's consent is copyright infringement. When it comes to literary or musical work, performing it in public amounts to infringement. And when we say communication to the public, it includes placing a work on a website or facilitating its download. A couple of months ago, a very popular website was taken down as a result of copyright infringement, Z Library. The people operating the website were arrested as they had put out books which were copyrighted for download to the public without the authorization or consent of the authors, thereby committing copyright infringement. If you're a Dan Brown fan and you've read the Da Vinci Code, it might interest you to know that there was a legal battle because of the book. Some two authors of a book titled The Holy Blood and the Holy Grail claimed that Dan Brown copied their work. Their claim was that he had based his book off the research they had spent years conducting to write their own book, their own sweat. He denied it, saying that he wrote the synopsis to the Da Vinci Code way before he or his wife read Holy Blood and Holy Grail, their book. Copying, publishing, performance in public, adaptation, communication to the public are all primary acts of infringement. But things like importing infringing copies, letting your premises to be used for infringing performance, providing tools for infringement, or supplying sound recording or films for an infringing performance, possessing infringing copies or dealing with them, or even providing means for making such copies are secondary acts of infringement, and can land you in trouble if you have knowledge that they're infringing copies but still go ahead to do those secondary acts. So what do you do if your copyright is infringed? If your copyright is violated, the things you can do are to first contact the person doing the infringing. You politely inform them of the infringement and ask them to remove the material or give you credits. You can also send them a cease and desist letter. If necessary, you can consult a lawyer to draft a formal cease and desist letter to them. And the third one is to take legal action. If the infringement persists, legal action might be required. Consult with a lawyer who specializes in copyright law. Once you've contracted the services of a lawyer, here are the elements you need to prove for your case to succeed. You need to establish that copyright subsists in the work. You need to show that that copyright is vested in you, you're the owner of the work. You also need to show that the person you're suing has done an act which is exclusive to you. Maybe they've reproduced or sold or published or even communicated it to the public without your consent. Another thing you need to show is that the person had no authority to do that act. You did not give them a license to reproduce or assign any copyright to them. And there you have it, a comprehensive guide to copyright law in Nigeria and how to safeguard your creative work. Remember, your creativity is valuable and you have the right to protect it. Share this video with fellow creators so we can all stay informed and empowered. Hit that like button and subscribe if you haven't already, and let's continue creating amazing content while respecting each other's rights. Thanks for watching and catch you next time.